Okay, we're on the record in clause number 135511. The case is styled the state of Texas versus ex parte uh, Robin Ray Weebush. And I have before me the amended petition for occupational driver's license. In this petition, Mr. Rebush has whited out or redacted the portion that said that his conviction was in, I guess, Colorado, and he's stating here in the petition that he is a resident of this county, which gives the court jurisdiction over this matter. Now, Mr. Weebush has been here. The court has been reviewing his petition and his amended petition for occupational driver's license. And Mr. Weebush was previously sworn in, and Mr. Weebush has informed the court that he currently has a state ID from the state of Colorado. Is that right?
No, sir. Since that application in August, I haven't been able to get into the DMV and get a Texas ID card.
You haven't been, repeat that?
I have a Texas ID card now. After, unfortunately, my appointment at the DMV was after our last court date. So I went ahead and took the time to go get an ID card, but I'll probably get to wait even a couple months if you were to sign this to even get back into the DMV. So,
okay.
Yes,
so
I did take that opportunity.
All right. Now, based on the driving record that you have provided to us, and it's from the Texas Department of Transportation, Texas Department of Public Safety, excuse me. At one time, you did have a motorcycle, well, you had a license from the state of Texas, is that correct?
That is correct, Your Honor.
And we show an expiration date of January 3rd of 2015, according to the records.
Yes, sir, Your Honor.
Okay.
That's correct.
Now, and then subsequent to this license, apparently you moved to Colorado. Is that correct?
That is correct, Your Honor.
And you, while you were in Colorado, you had obtained an adult regular license. In fact, let's just back up. The license that you received in Texas, your original issue date was in 2006.
Yes,
And then apparently was renewed, it was reissued, I guess, it was renewed in 2011.
Yes, sir.
And subsequent to that date, you must have moved to Colorado and you received a license in Colorado, an adult regular license in 2013. And it says, I guess the expiration date on that must have been 2018. And apparently that license was, oh yeah, I see in 2016, that was the during the time that you had the breath test refusal.
Correct, Your Honor.
And because of that, you were required to get, you received obtained a state ID in 2016.
That's correct, Your Honor.
And then in 2018, while you were in Colorado, you received an adult interlock license
Yes, Your Honor.
in conjunction with an adult restricted instruction permit. Is that correct?
That is correct, Your Honor.
Okay. And those licenses was January 2018 through February of 2020. Now you're back in Texas and you inform the court that you have a Texas ID.
Correct, Your Honor. Yes, sir.
Okay. All right. Now, And the court is going to make those findings that it just stated on the record. And it will state, basically looking at your order, the court finds that well, first of all, the court has heard the petition and application for occupational license, and you appeared before the court without an attorney, or pro se, you representing yourself. And the state was given notice of this hearing, and the state is appearing through its assistant district attorney, Mr. Ray Shearer. And let's see, the court will have your redacted driver's license number in the order. The court will also have a redacted expiration date in the order. And the order will also reflect that your last driver's license was issued from the state of Colorado on the dates that we've mentioned earlier.
Yes, Your Honor.
And the court also finds that you reside in this county.
Yes, Your Honor. And
the court, by examining petition, will find that you provided the court with the following: a certified abstract of your driver's record, and that was from the state of Texas as well as the state of Colorado. And you also provided the court with an SR 22 financial responsibility certificate. The court will also find that your driver's license is suspended because of the initial suspension was because of a breath test refusal in the state of Colorado on August 5th of 2016. And the court will further find that your license in the state of Colorado is revoked because of driving under insurance suspension and for violation of a license restriction in the state of Colorado.
Yes, Your Honor. The
court will also find that your driver's license is not denied, suspended, revoked because of physical or mental disability or non-payment of child support. And the court will find that the petitioner, has not been issued more than one occupational driver's license following a conviction during the past 10 years. The court finds that there is an essential need in that in the performance of an occupation or trade for transportation to and from the place of which the person practices the person's occupation or trade, or for transportation to and from an educational facility in which the person is enrolled, or in the performance of essential household duties. And I guess the court will find that the petitioner's driver's license is suspended because of an intoxication offense, and the occupational license here ordered is subject to the restrictions set out below. and the court finds the defendant has an essential need to drive, and the occupational driver's license here ordered is subject to the restrictions set out below. The court orders that the petitioner's occupational license is granted subject to the following restrictions, and orders petitioner to follow all restrictions listed below. The court orders the Texas Department of Public Safety to issue an occupational driver's license to petitioner subject to the following restrictions. The court further orders the Texas Department of Public Safety to administer any and all tests required for the issuance of said occupational license. And if petitioner passes all tests required, issue an occupational license to petitioners subject to the following restrictions. The petitioner must not drive a commercial vehicle with this license. Petitioner must maintain in full force and effect an SR 22 automobile liability insurance policy to the entire, through the entire period the occupational driver's license is in effect. Petitioner must have in his possession a certified copy of the court order while driving, and must allow a peace officer to examine the order when requested. Now, let's see, sure. There are some restrictions the court that the court can also add. Yeah, that doesn't apply. That counseling doesn't apply. Okay. And okay, so I'm looking here at, there's one restriction that says any vehicle owned or operated by petitioner must be equipped with a working ignition interlock device in accordance with Texas Transportation Code section 521.2465, and say petitioner must not refuse any lawful request by law enforcement for a sample of petitioner's breath or blood if stopped for driving while intoxicated. And petitioner must only drive to and from work or school and for essential duties including medical appointments, court appointments, attorney appointment, probation office meetings, and any supervision, education, counseling, or other essential needs authorized by this court. Do you have any objections to any of these?
No, Your Honor, the petition actually listed hours of operation, and they were 6 a.m. to 6 p.m. essentially Monday through Saturday with no driving on Sunday. And the state feels like that's restrictive enough to ensure that the petitioner is not out at night, which is when DWIs tend to happen. And also it is not so restrictive that he could not work in a business commonly, because most car dealerships are essentially maybe a 6 a.m. to 6 p.m.
Okay.
type operation.
So we're gonna include those hours
I would
of
include the
operation?
hours, and also since we are 4 years removed from his arrest on the DWI, I don't think the interlock would be something that would be necessary.
Okay. I was a little, concerned with the fact that the interlock, he had a violation of that interlock restriction up in Colorado.
Right, and the best I can understand, and maybe Mr. Weebush could give a little clarity here, is that the violation was that you removed it from a car that you sold?
That's correct. I mean, I've been an auto technician my entire life, and unfortunately, I paid the interlock company a lot of money after removing it myself. It was just something I can add to the list of things that were, not in my best interest to have done. But I sold the car to make, my next few months of a living.
Mhm.
And I know that this attorney and this court has had experience with interlock companies where we've had vehicles that were in fields flooded from hurricanes, that the people were still being charged the interlock fees and such. I'm not going to quibble about what happened in Colorado as to the validity of what he is stating before the court. He is under oath. So I have no doubt that that's probably what happened. But yeah, I can understand where someone in Colorado would look on paper that there was an unauthorized removal from a car, and that was it.
Right.
So.
Okay. Well, yeah, I think I'm just a little leery on in not including that, and like I mean, I know what he said. I don't, we don't have all his records or anything like that from Colorado, other than driving records, and that I think that's all that's required is your driving record and your SR-22 to be attached to the. But I think under the abundance of caution, I think I may just continue to keep that in there.
Okay.
Okay. Now,
If I may,
yeah.
So an interlock license, occupational license, albeit that does grant me the privilege to drive, no auto facility puts anybody with an interlock in their employment, unfortunately. That's a gracious offer, something I would still gladly accept. However, that doesn't really solve my problem with getting a job in the industry that I am skilled in. And it frankly wouldn't get my foot in the door anywhere to have that restriction, because my job is entailed driving other people's cars. And if those cars don't have interlocks, I can't legally drive them. And
well, we could do
back at square one.
Your Honor,
we can do
just to make sure Mr. Weebush understands that as long as his employer understands that he does have the interlock, then they can waive him having one on any vehicle he operates that's their vehicle.
that is a statute that says that.
And so although you may have to have one on your car, you're not required to have one on any vehicle you operate, so long as your employer is aware of the circumstances.
And again, to try and get your foot in the door with massive corporations that own about 90% of auto dealerships anymore, they're gonna put your application in the trash, unfortunately. Now, it's maybe not, but having been on the hiring side of management and auto shops before, I'm not wrong about that.
Yeah, but like I said, I'm just a little leery of doing that. So I mean, I'm gonna continue just to keep that in there.
Sure.
Okay, now let's see. Yeah, we got the dates and the times that you stated. And I think there's something. Okay, here it says petitioner must always keep a logbook in any car petitioner drives. Petitioner must correctly record the logbook, all dates and times petitioner drive, and the designation and reason for each trip. Petitioner must show this logbook to any law enforcement officer demanded. That's what does they say about that?
I can understand where in some cases with some defendants, particularly that come before this court with an original jurisdiction over a criminal case, that might be something we would want to impose. In the case of Mr. Weebush here, I just don't see the point of it.
Okay, so we want to include that restriction.
That's what an interlock does. is keep track of when you start the car, when you kill the car, you have to go pay to have it uploaded. The state will have that information from it.
I do see that there would be some redundancy there.
Well,
particularly with
that
this
makes,
vehicle.
yeah, I see what you're saying. That makes sense. Yeah, it well, okay. Okay. And the court, and then we'll put a date that the order takes effect. Now, I just stated into the record, the court's order. What I would have to do is, get a clean version, because, this one is, they have some marks on it, so I'll get a clean version. And then what we'll do is have the state take a look at it, and Mr. Weebush, you could take a look at it, and then we'll go from there with the sign. But